Today's episode is brought to you by Powbox, the easiest way to make your practice email HIPAA compliant. It works with the Gmail or Outlook account you already use, and your clients never have to log into a portal to read your messages. Get $250 off an annual plan with promo code MODERN.
When the session ends, the admin begins. From progress notes to insurance claims, managing a practice takes time. Simple Practice is the all-in-one EHR built specifically for therapists to streamline your workflow and give you your hours back.
Start with a 7-day free trial, then get 50% off your first 3 months. Just go to simplepractice.com. The Conversion Therapy Survivor Network, or CTSN, is a survivor-led nonprofit supporting people harmed by conversion therapy. CTSN provides survivor support groups, education, and resources for affirming mental health professionals. Learn more or support the mission at conversionsurvivor.org.
You're listening to the Modern Therapist Survival Guide, where therapists live, breathe, and practice as human beings. To support you as a whole person and a therapist, here are your hosts, Curt Widhelm and Katie Vernoy.
Welcome back, Modern Therapists. This is the Modern Therapist Survival Guide. I'm Curt Widhelm with Katie Vernoy, and this is the podcast for therapists about the things that go on in our practice, the things that go on in our profession, and the ways that we go about serving the clients that we serve. And we've been told since grad school that words have power. We've spent a number of classes. We've probably spent a number of sessions instructing people on how to make I statements and just even the ways that words being ordered tends to help people to heal and improve their relationships. But apparently the Supreme Court has been listening a little bit too well, because with the recent Chiles versus Salazar decision, they just ruled that our words have so much power that they're officially protected by the First Amendment.
I took it as they thought that our words were less powerful and it was just solely free speech and not treatment. But I digress.
So we are having a collective gasp as a mental health community, and this has basically thrown a grenade into state conversion therapy bans. It's a ruling that a lot of ethical affirming therapists are asking, wait, what does this mean for my practice, my profession, and when did SCOTUS become the supervisor of my counseling room? So we are here to kind of dive into what the Chiles v. Salazar decision, we're just going to call it Chiles for the rest of the episode, what it actually means, what it actually means for you, what it actually means for our profession, and we're going to do the deep dive into this. So unclench your jaws, drop your shoulders, listen. Curt and Katie are here.
So in March of 2026, the Supreme Court ruled 8-1 that Colorado couldn't stop a licensed counselor from doing conversion therapy. And on its face, it is like a dagger in the heart. Partially because of the, I think, initial perspective that it was seen as a de facto acceptance of conversion therapy, which is at this point pretty universally seen as really horrible treatment, very harmful, not evidence-based. And so I think a lot of initial reactions were based on that. But as we've been able to unclench and take a deep breath, the piece that worries me is the freedom of speech element of it. We've been talking about this together for a few weeks and reading through the materials and trying to understand what's going on. And I think a larger part of today's conversation is going to be about therapy being seen as protected speech, as free speech. My concern, especially paired with other things that are going on in the world, is that this is an element of deprofessionalizing our careers. That may be overstated, there may be some hope here. There is a concurrence that was filed by Kagan and Sotomayor that gives a pathway to how this might actually really only address the free speech issue and not make our therapy just talk. But especially initially, Ketanji Brown Jackson's dissent really sat where I sat, which is therapy is treatment and therapy as speech is not protected. And so I'm excited to jump into this because I think there's some nuance about freedom of speech. There's some nuance about how professions, professional associations, the licensing bodies regulate viewpoint, which I think is really interesting. And so I'm excited to dive into this because it is so nuanced. It is a really interesting kind of stack of questions that I think as a profession we need to start looking at and answering. And there's parts I just really hate. So I think that the best way for us to get started is to talk through the decisions and then go into what it means for us as a larger profession and as individual professionals. But I want to make sure that we frame this as we usually do. Curt is the current chair of the Ethics Committee for the California Association of Marriage and Family Therapists. I am a member of that committee as well, and we are not speaking for CAMFT or that ethics committee. The other thing is we're not attorneys. And so we're also recommending that if you have specific questions about how this might apply to your own practice in your state, please contact attorneys to talk that through. But we're going to, as folks who are interested in this, we're going to talk through how we understand this and put forward some questions that I think our profession really needs to be digging into now to be able to sustain what we do in the way that we do it.
So some of the background on this is just going to start with, for a lot of professional license history, and as we speak particularly towards healthcare and particularly behavioral health, mental health care, whatever you want to refer to it as, is that what therapists say to clients is treated by the government as the standard of care. There can be things that are dictated as far as all therapists can be expected to at least do these things. This is the baseline of what the state mandates. This is, at least theoretically, why we have licensing tests, is to be able to say everyone understands what at least the average therapist will do in most situations. And the state, therefore, is regulating our practice in the way that it would regulate any kind of medical practice. Now, what Katie was mentioning just a moment ago is that there is treatment, and particularly around things like sexual orientation change efforts, SOCE, gender identity, that there are aspects of this that are going to be in the way that it was framed. And I am going to say that I, at various points in this episode, might sound like I'm talking out of both sides of my mouth. There is what I personally believe, and then there is what I understand out of this decision and what is being said. So if maybe there's a little bit of disgust and despair when I'm saying things, that's more of my personal views coming through. And obviously not necessarily in agreement with this, but this is how the decision is affecting us. So SOCE is framed as having multiple parts of this so-called treatment. And what this case largely boils down to is where the line is on where the state can intervene. Now, Colorado's law, and this law is similar to many other states, was written that if you're a therapist and you are trying to talk people into changing their sexual orientation, their gender identity to be aligned with their assigned sex at birth, you can't engage in treatment with minors in this way. So the line is, don't talk about it. If clients come into you and they're exploring these kinds of things, there's some nuance to that version of it, but as a therapist, you can't just flat out say, I am going to change your gay child into a straight child.
And the converse is not true. And that is, you can affirm folks who are exploring gender identity and affirm identity and help them to transition, theoretically.
Correct. What happened was Kaylee Childs, a licensed counselor in Colorado, she ended up suing the state of Colorado because her viewpoint on this was that this prohibited licensed counselors from engaging in this as a discussion in talk therapy. Now, a little bit ago, I was trying to say that this is framed as multiple parts to SOCE, SOGI efforts, that there is the talk therapy version of things, and then there is the physically abusing kids, restraining kids, all kinds of other very horrible behavioral
Shock
abusive
treatment.
tactics. Exactly.
Yeah.
So Chiles's argument is that the talk therapy end of this was an unconstitutional limitation on her free speech. That, hey, it's just talk. Talk isn't abusive. I'm assuming this is very sarcastic. So I'm assuming that this is what it boils down to. Quick question for therapists listening. Do you use Gmail or Outlook for client communication? Here's something most therapists don't realize. Even with a business or workspace account, Gmail and Outlook aren't fully HIPAA compliant. That gap is on you to fix. That's where Powbox comes in. Powbox automatically encrypts every email you send, and your clients read it right at their inbox. No portals, no passwords, no extra steps. It works with the Google Workspace or Microsoft 365 account you already have, so nothing about your day-to-day changes.
Setup takes minutes, there's no training required, and Powbox's US-based support team is there if you need them. Listeners of Modern Therapist Survival Guide get $250 off an annual plan. Visit powbox.com, that's Paubox, and use promo code MODERN.
Well, and this seems to align with gender exploratory therapy and the treatment, I'm putting that in air quotes, that continues to talk and talk and talk and does not affirm someone's gender identity or sexual orientation. And so it is seen as, we're just talking, we're just exploring, and that can go on forever and ever, and it can, cause its own harm. The conversation today is not about that, but that's the way I understand it. Is that the way that you understand it, Curt?
Yes.
Okay.
So prior to this decision, what Katie was referring to, what a lot of us in the fields were looking at what we do as treatment, that the talk, which is what most of us do most of the time, is indistinguishable from conduct. And Chiles's argument is that those were two distinct things. Talk is talk, behavior is behavior. And this is really where the crux of the case ended up being, and what led the Supreme Court to decide 8-1 is that talk and conduct are two separate things, that talk therapy is pure speech, and therefore the government can't place limitations on it.
And more specifically, there needs to be stricter scrutiny of whether First Amendment can be, those rights can be withheld. So the concurrence that Kagan and Sotomayor put forward is that if it had been viewpoint neutral, potentially this would have been a harder question. It's the fact that only one viewpoint was restricted and was restricted in such a way. So I think there's therapy as speech, and then there's also viewpoint is not treatment. So I think there's a couple of things going on here.
And one of the big keys is what you're talking about here, which is the strict scrutiny. That there's a number of court cases that are kind of tangentially related to Chiles that we're not really going to get into here. At some point, I'll probably put out something that puts this all together. But the key phrase that you're talking about is strict scrutiny. And some of these tangentially related court cases are things that therapists have to say, and in cases like SOCE bans, things that therapists can't say. And the strict scrutiny test is how some things can be allowed or can be forced and other things can't. For example, just about every state has some version of the Tarasoff warnings that when a therapy client communicates to a therapist, a imminent harm, death, severe bodily injury to a reasonably identifiable victim or victims, there are things that a therapist has to do in those situations. And that's because it passes the strict scrutiny test. Now, the strict scrutiny test has two parts to it. Number one, the state has to have a compelling interest. So this is something where the state is really about keeping people alive in an imminent sort of way. I'm saying this intentionally in this way because we have just spent a month of episodes talking about how harmful all of the conversion therapies and things that all of our clients, as we're coming to a close in Pride Month, why we're celebrating all of the work and the being from this community and being allies in this community. I know that it tremendously leads to suicide, a lot of suicidal ideation, a lot of trauma responses across life. But the state of Colorado failed to say that there is an imminence in participating in this kind of talk therapy treatment. So it failed that part of the strict scrutiny test.
Because it didn't look at it and didn't have evidence for it.
It didn't have evidence that SOCE leads to imminent death.
Okay.
The other part of the strict scrutiny test is that it has to take place in the least restrictive means. So if we use something like Tarasoff again, we are making attempts to warn reasonably identifiable victim or victims. We're making attempts to have law enforcement intervene with the client. We're not necessarily broadcasting out on every radio station and every TV station that this person is out there. We're not arresting someone. So we're trying to do this in the least restrictive way. So what the Supreme Court is saying as far as this strict scrutiny test is the state of Colorado failed to, number one, prove that there was a compelling state interest. And number two is the least restrictive place in banning this isn't in preventing therapists from talking about this. The least restrictive place is preventing the conduct actions, all of those abuse actions. That's where the line moves to.
While I understand all of that, the concern that I think many of us face, and I'll acknowledge it here as Curt and I continue to walk this line of explaining this thing while also trying to be true to what we believe. Waiting until there is harm before enforcement is not great. And I think that's what is being seen at this point is that there's back-end accountability. If you actually harm a kid, just because you had free speech doesn't mean you won't have some sort of liability, you won't get disciplined. And so there's this element of keep talking. You can say what you want, but you might have consequences if harm is actually committed.
And so what this means, and this was written in the majority opinion by Justice Gorsuch, that the Colorado law engaged in viewpoint discrimination because It allowed for therapists to say words that point a client towards gender transition, but it banned words pointing them towards their biological sex. And what this means is because it's in this overreactive, overcorrective, the least restrictive place there, this is where it really challenges the idea of what our profession means. That there's a state guardrail that we've always kind of relied on that says, hey, other therapists are going to uphold at least some kinds of standards in being able to support people. And we can rely that because I have a license and because I at least treat people well in my practice, that other people who hold similar licenses to me can also be trusted because we've all had to meet the same rigorous challenges that our licensing bodies and our respective jurisdiction places say, hey, you can trust us because we as the state are holding these people accountable. And this is really, I think, where the decision isn't making SOCE legal. It's not making it a mandatory kind of treatment. And in fact, we're probably going to see a lot more therapists pop up who are engaging in at least the talk therapy version of these kinds of things. And that's hard because what it has done is it has made our profession less of the rigorous do good aspirational ideals all of the time and more of a collection of these are all people who managed to pass a test.
Mm, yeah. Let's talk about why Curt and I both use Simple Practice. Simple Practice is an all-in-one EHR that is HIPAA compliant, high trust certified, and built specifically for therapists.
For me, it's the integrated client communication. Messages from clients land straight in the chart, so I'm not copying things over from 3 different apps or emails or trying to remember who said what where.
For me, one of the things that saved me gigantic headaches is insurance billing. It was simple back when I was in network, and it stayed just as simple now that I'm out of network doing courtesy billing for my clients. That used to be the thing I dreaded most, and now it just runs. And if you're just starting out or growing your practice, they also have a credentialing service that helps you get paneled independently.
It takes the total headache out of insurance enrollment, giving you full autonomy over your own contracts without any middleman platforms taking a cut.
If you're ready to simplify the business side of your practice, now's the perfect time to try Simple Practice.
Start with a 7-day free trial, then get 50% off your first 3 months. Just go to simplepractice.com to claim the offer. Again, that's simplepractice.com.
I think there's an argument that some of that's already been happening. And this just is SCOTUS approved. But it is sad. I think there's this idea that when we aspire to be ethical and do evidence-based, positive, aligned treatments, that's a very different profession to be in than a group of folks debating what seems to be established baseline treatment.
Well, it forces us to sit with this really uncomfortable truth that a practice can be overwhelmingly rejected by consensus, by the research, and it can be seen as dangerous and unethical, yet it remains completely legal and constitutionally protected. And
Because it has been minimized to the term speech
yes.
versus treatment.
And so, there have been all kinds of things being said by all of the major professional associations, and we'll include links to their statements in our show notes over at mtsgpodcast.com that renounce the Supreme Court's decision on this and provide all kinds of evidence that says this is a slippery slope down to very well-researched and dangerous protections against people. People have been harmed and are going to be harmed even more. And I think I want to be able to kind of talk about what this means for those of us who aren't running headlong into this very stupid practice, uh, and what it means for the rest of us in this profession.
Yeah. So to finish out, just talking about the decision and what was written, I think it's important to briefly talk about the concurrence and then also the dissent, because I think the dissent is where the professional associations are sitting. The concurrence, I think, opens the door for looking at how do you adjust these rules, these bans, to be viewpoint neutral. And I don't know what that is. I'm not a legal scholar, but being able to help define the line between speech and treatment more effectively so that some of this treatment masked as just us talking does get called out. And that's what the Kagan-Sotomayor concurrence, I think, allows for. Don't just limit one viewpoint, actually define what it is that's harmful. The dissent is interesting, and it's really where I was landing initially. I'll read a few pieces here that I think are really worth reading aloud. Chiles is not speaking in the ether. She is providing therapy to minors as a licensed healthcare professional. This is treatment. Talk therapy is medical treatment, so why wouldn't such speech-based medical treatments be subject to reasonable state regulation like any other kind of medical care? In the context of medical practice, we insist upon competence, not debate. And my biggest fear, this decision might make speech-only therapies and other medical treatments involving practitioner speech effectively unregulatable. So what we need to be looking at, in my opinion, is how do we make sure that we are part of the solution in figuring out where speech turns into conduct or treatment becomes regulatable according to the law. Because while I recognize that I want to be able to say what I want to say, I want to be able to be a person out in the world and speak my viewpoints. We have a podcast. I want my freedom of speech upheld. I recognize that when I walk into the therapy room, virtual or in person, my ability to speak my mind is greatly changed. And I don't expect the Supreme Court to allow me to say whatever the heck I want just because it is a debate that's going on in the popular culture. I want the higher level of regulation that Jackson's talking about. And that's what a lot of the professional associations are aligning with. This is treatment, this is not speech.
Part of this question really comes down to where does the speech end up turning into conduct?
Exactly.
And this is, I think, going to be debated until whatever the follow-up case is.
Yeah.
And whichever courts that is going to be filtered through. I'm going to reiterate, I am not an attorney. I'm somebody who looks at legal stuff for therapists for fun. So,
and I talk to you a lot, so I get to have some of these wonderful conversations with you all of the time. So it is kind of fun.
So without getting super into the weeds on things, some speech is essentially just the operational mechanism of an action. For example, a doctor writing a prescription using words on paper, that act is prescribing medicine. That is speech. It is just an operational, here is a thing.
And still, because they are doing a form of conduct, which is prescribing, that is regulated.
Well, yes. Now, if the doctor in this case is prescribing a medication that doesn't exist, that's fraud. And that is still illegal in cases like this. So
Yes.
if a therapist uses speech to commit fraud, for example, billing for hours that they didn't work or sexually harassing a client, those laws are going to treat that still as speech that is criminal.
Yes.
The more abstract end of this is really where I'm curious where things are going to get teased out, because there's this blurriness that we're all trying to work through, but where does speech end up creating actual injury? And I think in this case, there's going to be protected speech, and then there's still going to be regulatable speech. And I think it's going to come down into some of the framing. So I think where the line has now moved is, and caveat, I am not saying this, I'm using it as an example. I think that where this is now protected speech is for a SOCE therapist to say, as your therapist, I believe your anxiety is caused by your gender identity, and we should work to align your feelings with your biological sex. I think that is now a legally protected viewpoint speech under the Chiles decision. The Conversion Therapy Survivor Network, or CTSN, is a survivor-led nonprofit supporting people who have been harmed by conversion therapy and other forms of conversion practices. Many survivors were told that their LGBTQ plus identity is something broken, sinful, or wrong they needed to suppress in order to be loved, accepted, or even physically safe. And for many CT survivors, those messages continue long after the therapy itself ends. Conversion Therapy Survivor Network exists to remind survivors that they are not alone.
They host weekly survivor support groups, share survivor stories publicly to raise awareness, and work to educate therapists and mental health professionals about the lasting impact conversion therapy can have. If you're a therapist listening to this podcast, your affirming care could genuinely change or even save someone's life. You can learn more, support the mission, or access resources at conversionsurvivor.org.
Until it causes harm.
Now, there is where this blurry line is, and where I think it's still regulable, is instructing a vulnerable, acutely depressed minor to cut off all ties from their supportive and affirming parents, or utilizing any kind of shaming or bullying disguised as therapy that still crosses the line into actionable negligence.
At this point, that's back-end regulation. That's the least intrusive is this caused harm, so now you're in trouble.
We, as a profession, operate on this word imminent. There's things that we have to do that require a certain amount of trying to prevent future behaviors, but it's mostly in the terms of things such as tear us off. The rest of what we do is still very much tied up in confidentiality. And while those of us with reasonable viewpoints on things that say, yeah, all of the evidence points to this eventually causing harm, there's not that state guardrail, that state line that's there to be able to protect us as much anymore. And I think that this falls more in line with state boards respond to when harm has already happened, not at the potential of harm from therapists. We've talked about this in episodes before when it comes to cognitive decline in older therapists, that until somebody has been harmed, the state doesn't really have a chance or the opportunity or the mechanism to step in and actually prevent somebody from causing harm, even if they're driving down harm highway in a harmmobile, shooting their harm weapons out at everything.
Yeah. So one element of this is harm. And potentially this is an opportunity for folks to document harm, for clients to make complaints related to harm so that there are, the case law or the regulation that at some point might become important in continuing this conversation. The other piece is that viewpoint neutral line. And I've been trying to think about, how do you make this viewpoint neutral? My my thought process, and maybe you have ideas. I know I'm throwing this at you right now. My thought is around coercion. It's about not getting informed consent. It's about failing to inform folks about best practices or standard of care. I think that, to me, neutralizes it, and it's also fairly vague. So I'm not sure where the open door from Kagan goes as far as, let's make this neutral, but I think that is something that may be of help.
I'm not sure I entirely agree with that,
Okay.
because I think that in order to craft something, it's just going to lead to a ban on all discussion around gender and gender identity with minors, whether
That's
it be
fair.
affirming or not. And I don't think that that is the right pathway forward. If anything, if this is the reality that we're in now, I think that this is more of an opportunity for us as individual practitioners and putting continued pressure on our professional associations. But I have some pieces of advice for individual practitioners in the world that operates post Child's decision. And I think that some of this is not relying on your license as a state approval of safety, that there are extra steps that we have to do, leaning into being a modern therapist, putting out how you work even more clearly. So ditch the euphemisms. Stop saying that this is an inclusive space and actually use explicit, searchable, unambiguous words on your website and your Psychology Today that says you are a gender affirming therapy practice, you're an anti-SOCE practice. Make it clear that you are not one of the people who is going to be doing conversion therapy, even if it is disguised as talk. And state that proudly, and signal that with safety. Put it in your FAQ section about how you work with vulnerable clients, and that way those clients and their parents can see how you end up working. I also think that if you're really concerned about this, you should sharpen your trauma informed skills in working with people from the LGBTQ plus community, because more people are going to get harmed as they are put into these practices. And you should have the clinical skills to be able to work with them if they feel that coming to a non-soci therapist is right for them in the future. Have those clinical skills, build on those. And I think lastly is adding into your clinical documentation, articulating your evidence-based and client-centered frameworks. So if you are practicing affirming care, that your interventions align with established clinical guidelines. In other words, this absolutely sucks as a new reality, but we don't have to roll over and just let this take over the field. That we can still continue to be loud voices about this. And while we can't rely on the state to control other people's practices, you sure damn well can make your practice loud and proud in how you go about working with clients from these vulnerable communities.
And at this point, the professional associations will back you. They are aligned with that advice. They recognize that the landscape is changing. There are questions they're going to need to ask themselves and sort through, and how they advocate, how they write their ethics codes, all of those things. But they are saying, if you do harmful care, you will be disciplined. You will be subject to discipline. You will be subject to liability. And so I think it is, in truth, little is changed for those of you who are practicing well. I love your advice, Curt, about loud and proud. say those things, put those things to the forefront, I think it really only provides a loophole for folks who are trying to do harmful care. And that infuriates me, but it doesn't change how I practice.
You can find our show notes over at mtsgpodcast.com. Follow us on our social media. Join our Facebook group, the Modern Therapist Group, to continue on with this and other conversations. And until next time, I'm Curt Whithelm with Katie Vernoy.
Thanks again to Powbox for sponsoring today's episode.
Powbox helps therapists send and receive email that's secure, HIPAA compliant, and easy for clients to open. Get $250 off at powbox.com with promo code MODERN.
If running your practice feels like too many moving parts, Simple Practice pulls scheduling, billing, and client communication into one place.
Start with a 7-day free trial, then get 50% off your first 3 months at simplepractice.com. The Conversion Therapy Survivor Network is working to support survivors everywhere and bring an end to conversion therapy. To learn more, donate, or access educational resources, visit conversionsurvivor.org. That's conversionsurvivor.org.
Thank you for listening to the Modern Therapist Survival Guide. Learn more about who we are and what we do at mtsgpodcast.com. You can also join us on Facebook and Twitter. And please don't forget to subscribe so you don't miss any of our episodes.